Welcome to the Transparency Live. Vandal Nation
was definitely worried about how long it was going to take.
The big story on Action News tonight is a major break in the murder of 4 Idaho college students. The arrest of a 28-year-old man in connection with the brutal murders of 4 University of Idaho students stabbed to death in their beds more than a month ago.
At about 2 a.m. on December 30th, 2,500 miles away from the scene of the murder, SWAT teams are breaking into a house in eastern Pennsylvania to make an arrest.
A break in the case that has gripped this nation. Police arresting a suspect, PhD student Bryan Kohberger.
He's facing 4 counts of first-degree murder and 1 count of felony burglary.
Media press releases were written almost daily by an officer from Moscow Police Department.
This was finally proof to the families that investigators had been working the entire time on this.
This was a big step forward in hopefully the beginning of healing for a lot of people in this community, the university, the families, and bringing justice for those victims.
Investigators are working all right. Not just Moscow Police Department, but many agencies across Idaho as well as Washington, and even nationally, with an FBI task force of more than 42 agents assigned to this case. According to the press releases, Captain Dollinger of Moscow Police Department had a very important task, keeping the public updated, and most of all, panic-free in their little college campus town that is not used to violence. With the arrest of Bryan Kohberger came much relief for not only the victims' families, but the community. So many people were waiting to get the probable cause released due to it being sealed, due to Bryan Kohberger not being in Idaho and having to be extradited. This process took extra days, but it was finally released. A probable cause that would put a stamp on why they arrested Bryan Kohberger, not for just for 4 murders, but also felony burglary. On November 13th, when Moscow Police Department first issued their first press release that was typed up, at the bottom, the Moscow Police Department does not believe there is an ongoing community risk based on information gathered during the preliminary investigation. November 14th, the second press release. For anyone with information related to the homicide, please contact the Moscow Police Department at 208-883-7054. All press-related inquiries should be directed to Captain Anthony Dollinger. November 15th, we All right, we are back. Sorry about that. I have no idea what happened. But when you try to keep people down, they just, the real ones just pop right back up. Okay. Now, where were we? Jeez. Okay, here we go. Campus town that is not used to violence. With the arrest of Bryan Kohlberger, press release that was typed up, at the bottom, the Moscow Police Department does not believe there is an ongoing community risk based on information gathered during the preliminary investigation. November 14th, the second press release. For anyone with information related to the homicide, please contact the Moscow Police Department at 208-883-7054. All press-related inquiries should be directed to Captain Anthony Dollinger. November 15th, we would see a double press release. Moscow Police Department releases that they determined early in the investigation that we do not believe there is an ongoing threat for community members. Evidence indicates this was a targeted attack. We are working closely with Idaho State Police investigators and with the Latah County Prosecutor's Office. We are utilizing many other resources within law enforcement community to bring about a fast resolution to this incident. As soon as we have more information that we are able to share with the community, state, and nation, we will. Moscow homicide updates again on November 15th, the second one. Although no weapons have been located, based on preliminary information, investigators believe that an edged weapon, such as a knife, was used. Also, based on information from the preliminary investigation, investigators believe this was an isolated, targeted attack, and there is no imminent threat to the community at large. This would be the first time on November 15, 2022, that Moscow Police Department used the term isolated, targeted attack. The Moscow Police Department claimed that they were working closely with the Idaho State Police, and now for the first time they announced, as well as other state and federal law enforcement partners on this case. For me, and many others out there, it's never been about that we didn't think Moscow police, other agencies, were working on this case. It was about what they were working on with this case. That took several weeks for an isolated, targeted attack that the police department immediately deemed that there was no imminent threat to the community. There is a difference of what you're working on versus who you're working on. The Moscow Police Department initially said that when they were able to release information both to the community, to the state, and to the nation, that they would. And at those times that they were able to do that, that they would. There was never a time where Moscow Police Department said that we would use our press release as well as television pressers to misguide the community. And so you have to ask yourself, why? Why? Again, the day before the first television press conference on November 15th, as that television first press conference would happen on November 16th, in the media press release, it says that we are working closely with Idaho State Police investigators and with the Latah County Prosecutor's Office. We are utilizing many other resources within the law enforcement community to bring about a fast resolve to this incident. As soon as we have more information that we are able to share with the community, state, and nation, we will. Well, what they shared with the community, with the state, and with the nation was that they were looking for a 2011 to 2013 white Hyundai Elantra. Never once changing the years of that Hyundai Elantra, and in fact flooding their own tip line beginning December 7th, 2022. Why? They had on November 29th, 2022, Bryan Kohlberger's white Hyundai. You guys remember? I mean, everybody thought this. So much so that Judge thought this. Now you're going to sit here and tell me that Megan Marshall read that affidavit and didn't think that they had Bryan Kohlberger and wasn't investigating him beginning November 29th? Lies. Absolute lies. Elantra, 2015, being reported by WSU campus police, and that being passed along to none other than investigator Officer Payne. I didn't get that. Well over a week before asking the public for help with a wrong dated vehicle. Why? I, like so many others, when I first read the probable cause for Bryan Kohlberger's arrest, thought it was beefy. Thought it had a lot. It was 18 pages. I actually read it for the first time on a live broadcast. It wouldn't be until that next day, literally the next day, when I came out and said, after reviewing this PCA in more depth, this is all circumstantial, to the point of questioning why we were misled as a community and as a nation to help in an area where they knew that that help would in no way, shape, or form possibly be able to aid in this investigation, but yet came out asking for the community to put aside whatever it is that they were doing and be on the lookout for a 2011 to 2013 white Hyundai Elantra. You guys remember jail? The police department captivated mainstream media to the point that that's the only thing that anybody was talking about with the Idaho4 case, was all about this white Hyundai Elantra. In my opinion, it was to take our attention away from other things that were going on within this investigation, which wasn't a simple investigation. This was, and it will come out when it's all said and done, a very complicated case, very complex, a lot of moving parts. But then you have to ask yourself, if this is so complex and so many moving parts, was this an isolated, targeted attack? Exactly. And was the community at large to not be feared in any type of way by the person or persons responsible? Because how complex are we talking? And those answers come here now when we talk about the discovery, the requests that were made by Bryan Kohlberger's attorney, Ann Taylor, and then the response that was given by the prosecutor's office, Bill Thompson's office. And if this doesn't put a stamp on all the red flags that myself and this channel has pointed out since day one, then I don't know what will. I think the first thing that I wanted to talk about and just get out there on the record is the felony burglary charge. That tells me that the state will be put. I'm not going to play my hand there. All right, so let's take that down. Okay. Welcome, everybody. What's up? What's up? Yeah, here we go. Taking us back to June of 2023. So the wheels fell off December 2022. We talked about that last night. Now let's take a look at June 2023 when Ann Taylor literally hit the prosecution with a bag of dicks. Okay. All right. I'd like you guys to welcome to the show, Hector. And for those of you guys that were able to not really see some stuff last night, if you guys want to take a screenshot of this, you guys can. I did it with 2023. There you go. There you go. Remember, we have a huge suppression hearing, guys. Huge suppression hearing. But that's the 23rd. And let's see. Those are all the timestamps that you need to know about. So, all right. From June 16th to July 14th, it was a freaking war zone of 2023. 2023 war zone. Here you go. So, there you go. We'll zoom in here. This is the piece of paper that you would need if you want to be following along. It is, there you go. June 15th, 4:30, defendant's second motion to compel discovery. So just to show everybody what Bryan Kohberger's team was still asking for, they asked for it immediately out the gate. And then here in June, you know, they can't even damn get, here you go, investigative reports and conclusions from all cell phone analysis, including but not limited to any analysis conducted by police agencies, FBI CAS team, or other Idaho authorities. The state has responded by listing page numbers and audio, video file names of information and data provided to the defense in discovery. As of June 13th, 2023, counsel for Mr. Kohberger has not received any investigative reports and conclusions of any analysis of this data conducted by police agencies. The word reports. Okay? Investigative reports and conclusions. Number 4, asked for it in January, still asking for it. All footage provided to forensic examiners with FBI used to identify make and model of vehicle. All reports generated related to the identification of the white Elantra. The first report ever generated, by the way, guys, March 21st, 2023. Just so we're clear, probable cause was established that they said when the wheels fell off December 23rd, 2022. Yet the first report, and that was needed because did they use that for the grand jury? All this shit. Now go ahead and ask yourselves. Now we're waiting for the suppression hearing to happen, right? What was Payne being asked of on that stand? What was Mowry being asked of on that stand? Okay. All of this shit. The state has responded by listing various page numbers and file numbers and recordings that they have previously provided. However, they do not provide any reports, generated communications, and documents related to the change in year. To the change in year. What was that asked for of Payne? Oh, I just talked to him. He just told me. He just told me what in person. Remember the change in year? Like, when did this happen? Oh, the 20th of December. The 19th was when they got the name Bryan Kohberger. Wait till you guys want to know another important date to write down is the 17th. And the 17th is when the 3 other DNAs were known male. So they knew about these 3, the lab did, 3 unknown male profiles on the 17th, didn't do dick with them. The 19th, Bryan's name comes from the FBI. December 20th, Payne, hey, do you think this could be a 2014, 15, or 16? Okay. This whole report, this was not given to the defense until 2024, when Syre testified. So what was that, like the 28th or the 30th or whatever that date was? Okay, just so we're clear here. They arrested Bryan Koberger on December 30th of 2022 off of this car shit. Okay, arrest. This report was done allegedly on this date. The defense had it on in May 2000, almost a year later. Okay. Next thing they were asking for was request 17, and they were kind enough not to put it all in there. Request 23, request 109. Again, this is just like, hey, we're still asking for it. Don't get it. Identity of the FBI special agent that is a member of the cast team that was consulted with to determine locations of the cell phone from 11-12 and 11-13 and all cast certification records. So again, this is when we find out that this was Nick Balance, right? And we find this out from Payne, and they find that out in 2024 in May. Okay, the day before, right? When were they asking for this shit? They were asking for this stuff in January, when the first discovery came out of 2023. This is what their case is built off of. So when you want to talk about this suppression hearing, they've been hiding this case the entire time. They've been asking for this stuff from the beginning. And the people that are delaying this, the people that are the ones that are not, I'm going to say it. When you want to talk about the victims' families, it's not the defense that's slowing any of this down, playing games. It's the prosecution. It's right here if you read. The state has objected to the request for the reasons that it is outside the scope. Okay, so this is about, hey, it's outside the scope for us to get this, the cast, because you use an FBI agent and you said that you used cast to, make the loop-de-loop with the car and the phone, right? So then the defense is like, or the prosecution's like, hey, we don't have to give you any of that stuff, okay? Mr. Koberger disagrees, as this information was largely relied upon in various warrants. So now, why am I talking about this? Because this is the 2-week countdown from this big, this is the trial for me. Okay, this court date, in my opinion, is bigger than the actual trial. I'm not playing. Everything's going to be decided at this huge hearing. This is decided of what's in, what's out, and what's truly gone on in this case. If the prosecution brings it and can back up everything that they've said since day one, that'll be a miracle. And I'm praying for it for the victims' families. But I, however, I'm a gambler, and I just put $100,000 down in Vegas on the fact that the prosecution's going to get their asses kicked. Because I don't believe that Cyray's been lying, and I don't believe that Ann Taylor's been lying. Next. So again, Mr. Koberger disagrees, as this information was largely relied upon in various warrants. Is that a lie? No, that's 100% factual. Information relied upon to secure search and arrest warrants is necessary to conduct analysis of Fourth Amendment issues. Further, the entirety of the information could include materials required under Brady. You guys know what Brady is. We're going to talk about Brady at the end of this live. Idaho Criminal Rule 16 covers broader area than the evidentiary rules of admissibility. Request 120 and 140 is all tips. There it is. All tips. So that would be, here, Bryan C. Koberger, investigate him, right? From FBI, pertain to IGG, right? When that come in, the tip line. The state has provided various tips throughout discovery. However, they are scattered in pieces throughout the discovery. A complete and chronological list of all tips has not been provided. You would think that it would all just be, here's all these emails that we were getting because we had this tip line and we had this email. You submit stuff digitally with this case. So the FBI had one. So the FBI should have their own. So the FBI just submit their own tip to their own tip line. And then you had the MPD had one. Okay. What about phone records? What about phone records? Like, we want MPD's phone records to see who was calling in these tips. If you're not going to, I mean, could we just get some phone records here? Next is all recording related to all search warrants. Why do you think they wanted that? Because proof upon sworn oath, right? We want to hear what y'all said to see whatever was talked about. If it's not in that written piece that you guys provided, right? Ann Taylor all over it. Ann Taylor all over it. But why was she all over it? Because she was reading the forms. They're all over it because, but guys, this was requested back in March. They told on themselves. They acted like it didn't exist. Ready? The state has responded that they are attempting to obtain this information. If it exists, the state will comply with this request upon receipt. The defense has been provided with a photograph of a DVD, a photograph, so not the stuff, but a photograph of a DVD entered into evidence as item 435, labeled SW audio. This is also a notation that this DVD was copied to county on 1/13/2023. So remember, this is a request here. She's writing this up in June of 2023. They were supposed to have a preliminary hearing. Ann Taylor has none of this shit. She's been asking for it since January. So January of 2023. This form was written, this was June 2023. They were supposed to go for the prelim in June. This is all the stuff that she did not have done. And still to this day, what is she missing? And then request 164 was body cams, recordings, notes, photographs, and all information collected at the autopsies. So now we want to get into this autopsies. And then this is where I found out those names. And this is how it got me on to the Moore case. Okay, boom. Now, after this was filed on June 15th, then on June 16th, literally the next day, the state comes and files this 33-page they're trying to get a protective order because Ann Taylor was trying to get the IGG, right? Well, I'm going to point out a couple of these things. Here you go. Happy birthday again to the cane right there. So the state writes this as their motion for protective order. Again, June 16th, 2023. Law enforcement found the DNA of potential suspects at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. The FBI then used common genealogical techniques to develop a family tree leading to the defendant. The state seeks to protect. Who are they protecting this shit from? The state seeks to protect from disclosure. I could see if you don't want me to have it or you don't want you guys to have it, but why are you seeking for them? Okay. Protect from what? Whom? What? Where? What? Oh, the defense. From having the names and personal information of the hundreds of innocent relatives on the family tree. Oh, so you care about people? Well, why don't you start caring about the victims' families? If you were caring about the victims' families, you wouldn't be doing any of this shit. Now this is where it gets good. So they want a protective order so that they don't have to turn over any of their work, and they're claiming that it's because of these victims or these innocent people that were used. Bullshit. Okay? Absolute bullshit. If they cared about them, then they wouldn't have did a loophole if they even truly did IGG. Including the state's privilege to protect the identity of us as informers, as described. So we're now in confidential informants. Okay? No joke. That's the rule of evidence 509. Right here, I think this is funny. They say this is the factual background of the case. Okay? This is William Thompson saying this is the factual background. You guys remember when I just read it off yesterday, Judge, he just writes the background. Okay? Well, this is some of the stuff that he took that from. So Judge in his order says just background because nothing in it is facts yet. There's no facts been determined. All right? So this is the background. So you should just be writing background, just to be clear. Now, this is what I want to point out. These would be my questions. Remember, this is a suppression hearing. This is a Frank's hearing coming up. So here's my questions. Now, the defense, they may already have this because I don't have what they have. But right here when it says law enforcement found a K-bar knife, who in law enforcement? Question number 1. Question number 2, on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter on the bed. Well, then my next question is how did anybody see anything from the door? Or how did anybody see anything, period? Because you're not supposed to be touching anything. Like Payne wouldn't have been touching anything. The only people that could have found a damn thing would have been the crime scene, people that were processing the crime scene. Okay? Okay. Law enforcement, again, who? Law enforcement seized the K-bar knife sheath. Oh, wait, one other thing I want to talk about. Where's down? I don't think they mentioned it yet. Okay, here. Law enforcement found a K-bar knife sheath just on a bed next to the bodies. It doesn't say like, oh, right here. The sheath was face down. That means the button snap where this touch is located is literally on the sheets, possibly on the body, but it's face down. So damn well it's like on the sheets. Okay. Law enforcement sees the K-bar knife sheath. The ISP laboratory determined the DNA came from a single source and that source was male. Okay. So that's what they determined. Now, here's my questions. Law enforcement, again, submitted the STR DNA profile obtained, and I believe they did it in the Boise lab. So Rollin is who I believe did it. Okay. And so then they put it through codis. No match was found. The only thing they could tell was that it was male. Unable to find a match using STR DNA analysis, law enforcement decided, again here, when was this decided and who made the decision and how was this communicated? Okay. And that would be law enforcement decided to use investigative genetic genealogy. So everybody out there that wants to say that it did not start when ISP had it, check this out. Unable to match using STR DNA analysis, law enforcement decided to use investigative genetic genealogy to find a lead. To find a lead. That means you didn't even you didn't even have one. Genetic genealogy also allows individuals to trace, and so we're going to go right here, which is they reference Ancestry.com and 23andMe when they're just trying to say what it is to judge. The genetic genealogy service then creates to use for genealogical purposes. SNP profile is different than an STR DNA profile. Claps. Now, the genetic genealogy service then uses an algorithm. Well, God, I would love to know that algorithm. To compare the user. So he's, again, explaining this to Judge. Okay. And then right there, it can't be any bolder, but potential relatives. Family trees can be used to narrow down a potential suspect based on factors such as age, gender, opportunity, known physical characteristics. And this is where it's just like, okay, so you had to use the BAU to, like, when you're talking about why would you like not put so-and-so in your, like, that's where I believe that the algorithm is coming from. Like, who are you automatically throwing out? Well, you're throwing out any females, right? Anyways, but then when I saw that it was going based off of like, well, also known physical characteristics of the suspect. Wait a second. Again, guys, we're coming back to Dylan and her stupid ass bushy eyebrows. Okay? Like, you cannot, when people are out there talking about that Dylan isn't so heavily involved in this case, Dylan is involved in this case like you would not believe because of the documents. And Bella loves when I say documents, so documents. I don't think she can hear me, but anyways, in this case, investigators, again, who used IgG to begin the process of developing a lead to the individual that left DNA on the K-bar knife sheath. The Idaho State Police utilized private laboratory to develop an SNP profile from the DNA. Okay. Exactly. Who did you use? Where's the communication? This is completely different to the affidavit says it never mentioned any of this in the PCA. And in fact, in oral arguments, Judge specifically asked this question. Okay. Did you use IgG at all for any information? Any information that you got from IgG, was that used in any of your search warrants? Was that used anywhere? Okay. And they were over here saying, no. When we say, yeah. They were, no. Okay. It says it right here. In this case, investigators used IgG to begin the process of developing a lead. Come on. I mean, Ann Taylor has to be using this. I mean, it's their own friggin' words. I mean, it's pay the lady. This is William's own words. This is what we're here. We're here for a suppression hearing. Okay. Then the Idaho State Police, they're the ones that gave it to the lab that they use. All right. Now, this is where it's going to get interesting. The private laboratory started, okay, I need to know when. What is the date? And out there, okay, people have said, hey, Lana, well, I have this thing that Ortham, that we have some, receipts, and there's been swirling around this November 29th date. Okay. I'm going to take another look at that. But here, it's just, give me the emails. Give me the emails. What are the dates? All we need is dates here. Okay. What is the date? So when this private lab, they started it. So the FBI did not start it. That is a myth. Okay. That is a friggin' myth. So the private laboratory who works with Idaho State Police, because to do this portion of what they do, they started using genetic genealogy to develop a family tree. But after law enforcement, again, now here's my next question. Who made this decision to decide to tell them that the FBI would take over? What is the date? Where are these communications? Where are these emails? The private laboratory ceased again when, and then it ceased its efforts and sent again when the SMP profile to the FBI. You guys, what day was this on? Because it's great that the FBI came up with this name on December 19th. Okay. Whose decision was it to send to the FBI? Was it because they had it and they were trying to develop and they couldn't do it? And they said, well, we need to send it to somebody that's actually like, we have to send it to somebody else because we were unable to do it. Just read don't try to like think more into this. It says it right here. The private laboratory ceased its efforts. So there was efforts made to try to do what? Build this family tree, right? And they couldn't. So when everybody asks me, who do I think's being subpoenaed? Who do I think's going to be at the suppression hearing? You're going to have to lay out this timeline for this judge to show everything that happened in this case and that it was all misled within the probable cause affidavit. And in order to do that, you need the people there that can testify to these dates and timestamps. All of this. Now, the reason that this is all put out there is because that Bill Thompson's writing this up, or whoever wrote this up for him, is because Ann Taylor is repeating, asking for a motion now in order to have the state compel all of this shit, right? But so you have to just go back to what he was saying in the beginning. And to sit here and say to the world that you did not use and did not rely on any information from IGG to do your search warrants is a freaking complete lie. Again, you need all these dates, everybody that was involved. So just because the private laboratory ceased, let's say that they stopped on just like the first of a day, like the first of the month. Okay. Then by the time somebody else got it, and then then we started on it like on the 10th. You know what I mean? Just because one person ceased doesn't mean somebody else immediately started up. So I want to know all these dates because we want to know what the investigators were doing when IGG is just being done in the background. Like, you don't know what's going to come of that. You should still be, investigating this case like you would any case. So the FBI uploaded again when the SMP profile to one or more publicly available, and then again, which ones, based on the information the FBI could see in the genetic genealogy service portal. Which portal? Law enforcement portal? Or, anyone portal. You have to have a receipt. If you do it the right way, you'll have a receipt, which they have not produced. The FBI went to work building family trees of the genetic relatives to the suspect DNA left at the crime scene in an attempt to identify the contributor. So who identified the contributor? IGG. Not Officer Payne when he says that I looked at Bryan's ID and said, okay, yeah, he has bushy eyebrows because that's what Dylan said. Get out of here. Okay. For ease of reference, this motion focuses on the FBI's IGG efforts. And this is important, and I hope Ann notes this to say, okay, yeah, we want to talk about the efforts that were done when Idaho State Police Lab sent it to, I don't know who, Ortham or whoever the hell they used. Okay. We want to talk about those efforts too, because we want all the dates. Because it's all going to come down to this chain of custody. And this is what they wanted to, what I say they, the state did not want to have to produce any chain of custody on any of this shit. They were trying to protect the chain of custody. I'm like, excuse me? You guys, I am all for and fine them using IgG. I'm just wanting everybody to know that they hid the fact that they used IgG on every single search warrant that they went and obtained. And there is no way you're getting to Bryan Kohberger without the IgG that's now coming from, that's the question is, okay, well, let's see if the Idaho State Police efforts with whatever lab they paired up with could not produce anything, right? Now how do we know that what you sent, I want to just compare everything. I want to compare that what Idaho State lab or whoever the Idaho State Police use, that what they have is exactly what the FBI used. Everything matches here, right? The FBI then sent, again, what's the date, to local law enforcement, a tip, again, how did you send it, to investigate defendant. It just, like, the paper trail. Where are the emails? Okay. Text messages. The IgG process pointed law enforcement toward defendant. I mean, it's right here. The IgG process. So how can you sit here and say that you did not use IgG in your efforts to arrest this man? But it did not provide law enforcement with substantive evidence of guilt. And here's my question. Ready? What do you have besides that, Sheath, that points to his guilt? And the answer is nothing. Nothing. Absolutely nothing. The FBI did not, for example, conduct a direct, no shit. And now this is just confusing language because they're just trying to confuse judge because nobody is saying that that's what happened here. Okay. The type of direct comparison required the more traditional STR DNA analysis, which was conducted by, again, after arrest, by the Idaho State Police, again, after arrest, not the FBI. Okay. Get this through. This is where this is gaslighting. That's just what that is right there. That's just gaslighting. But if you break this down, this was, it was conducted by the Idaho State Police exactly after his arrest. And you were able to get his arrest and then on January 5th, able to get a search warrant for his DNA to take a swab based on what? If this isn't fruit of the poisonous tree, then I don't know how. Show me a case where it is and then compare it to this case. Prior to the FBI's IgG efforts, so prior, the ISP laboratory developed the traditional STR DNA profile from the DNA found on the K-bar knife sheath. Yeah, no one's saying that they didn't. After identification of defendant, law enforcement recovered trash from the home of defendant's parents and ISP laboratory. But I said, wait a second. After identification of defendant, from what? IgG. Like, are you kidding me here? It wasn't from November 29th and running a parallel investigation with the car. That's not what this was. You guys, they're telling us right here. And so then when you look at this probable cause affidavit is, okay, take everything and just, why do you think I kept saying, wait a second, how did they get to Bryan Kohberger? How did they get to Bryan Kohberger? Oh, they left out how they got to him in the probable cause affidavit. IGG. But why can't you put, like, why wouldn't you talk about that? If you truly did it, at IGG, why wouldn't you talk about it? Because you are allowed to talk about it. There's all this case law, case precedent, backing it. And then it dawned on me, you wouldn't talk about it because what if you didn't use it? The information provided to local law enforcement by the FBI was nothing more than a tip, a lead for local law enforcement to follow up on, should they choose to. Okay, exactly, ready? And when they would have gotten this lead, the first thing they would have saw is, okay, wow, we took the name. He's not on any of the cell tower dumps. Okay, he wasn't in the area. His phone wasn't utilizing any of, but then we had to figure out how can we have his number. Okay, well, he happened to get pulled over and he happened to give up his cell phone number. So then therefore we were able to then look at the cell tower records, see that, okay, he's not on there though. Okay, no, we didn't need to do any search warrants yet, anything. Then we just simply type his name into the computer and start, looking up his social media, Google searches using subscription-based, finding out who Bryan Kohberger is, right? No search warrants needed yet. Again, this tip did not prove or substantiate defendant's guilt. And then here it is, guys, right here. Ann Taylor just has to say this. The state is saying this tip did not provide or prove the defendant's guilt, right? That's what they're saying. Rather, the tip allowed local law enforcement to focus. Here it is again. Now we're going to focus our investigation, to focus their efforts. So everything came from what? IGG. Okay? We're focusing their investigation on defendant and obtain independent material evidence of his guilt. Now, what did you obtain independently of his guilt, all of which the state has disclosed or will disclose? And here's my thing, which was what? What in there is, and then it comes to this, guys. This is where the big FU comes. I'm predicting what's going to happen here on January 23rd. Is you point this out and then you say yep, then they padded the stats. Then they made up. What that means is padded stats is you then lied about the data and what it represented to then make it seem like this suspicious vehicle, this white car, okay, and this phone that you say belongs to Bryan Kohberger, okay, because you're able to Google his name, put him in. Oh, yeah, he was pulled over. Oh, God, look at this. He gave up his cell phone number. Then we're doing all that. Awesome. Great. And then this is where you're going to get your possible suppression, in my opinion, is going to come from right from this, which is They knew that they didn't have enough. They knew that they didn't have anything. But they were so hell-bent on the fact that, well, his DNA's on it, man. It's got to be him, man. It's got to be him. Okay? That mentality. That what do? It's called railroading somebody. It's called taking evidence that you already have, okay? And well, we're going to go ahead and make it so that the Elantra and this phone and we're going to lie about the data. And now that is where this is how it's going to be. This is how I would portray this, right? How would you portray this to Judge Hippler to say, Judge Hippler, this is what they did. And I'm not going to portray it because I'm going to tell it to you. I'm going to have all of these witnesses get up on this stand and tell you exactly what they did. And then I'm going to have my expert come up here and we're going to put a timeline versus timeline and show you through their own words, through on the stand, their own motions. This is what they did. And then they lied to get search warrants. And then Judge Hippler has to decide if that's accurate. But when you start talking about dates, like on December 17th, you guys, they knew 3 other male DNAs profiles that they had, okay? And they did nothing to try to figure out who the hell those people were. They could have potentially then led them to this person's that's on the knife sheath because they're friends or some shit like that, okay? The word probable cause is going to come from what? Because remember, they didn't use anything about IgG to get probable cause. So your probable cause is coming from what? It came from what? What did your probable cause come from? To get search warrants. And what did you get them for? And then what did they prove to you? Let me just ask you guys just a very simple question. Why not just go and try to get Bryan's DNA, or you go and get his dad's DNA, right? And then you would just, once you would have got it and you would have tested it and it's a match, why can't you just say what you truly did? And that it was we got a hit. To the extent that the IgG information has any relevance, ready? And this is where I'm just going to say, Ann Taylor, you're welcome. Thought about this long and hard. To the extent that the IgG information, this is the state, has any relevance, the fact that it led law enforcement to defendant means it's inculpatory, ready? Rather than exculpatory in nature. I said, nope. You want to know why? Let me tell you why. The cell tower, right? The cell tower data didn't lead back to Bryan Kohberger. The cast should have cleared him because it was not matching up with the movements, right? So it is actually exculpatory. Using this is actually exculpatory because if they say that they would have used it, okay, then you're able to go through like anybody would. Here's the name. Okay, well, it doesn't come up on the cell towers. And then what does Payne do? Makes an excuse and says, nope, he shut off his phone. Versus that, no, it's horrible service out there. And, no, okay, so fine, we'll give that to you. But then the cast, that doesn't match. So everything is ixnay. And so you can keep Bryan over here in this, little bubble, okay, because this touch DNA on this placed sheath, everything was striking out. That's the only thing against this man. How does that add up? There is more against Karen Reed, and everybody's screaming Karen Reed's innocent. You guys understand that? There is more. When I'm saying more, there is like 10 times more evidence against Karen Reed than there is against this man. And I'm over here just like when people are like, Lana, you're crazy. Well, you really want me to compare Karen Reed case to this case? Because there is hella way more evidence against Karen Reed than there is against Bryan Kohberger or anybody for that matter. Anybody. Now, IGG is not inculpatory. It's actually exculpatory. Because then you would have taken your little lead, and then what would you have done? You would have figured out that, oh my God, well, none of this data is supportive of it. But what do they do instead? They jimmy rig and lie about what the data of the cell towers is saying. And now if you don't think that that's on the level of Proctor punching out the back of a frickin', pumping out the back of the Lexus taillight and doing all that shit, okay? And if you don't think that that's the same thing, then I think that you need to go get your head examined, okay? Like, and soon. I didn't say that Karen Reed isn't factually innocent. I'm saying the reason that there is any evidence against Karen Reed is because she was framed, right? That's where this evidence exists from, being framed. Same with this case. The evidence exists against Bryan Kohberger because it was framed evidence. It doesn't match. They lied in search warrants. They did the same thing to Karen Reed. And everybody is saying and screaming she's innocent. And nobody wants to look at that case the same way as this case. And I'm scratching my head as to why. If you want to just let's just look, fuck who the person is. Hot blonde, dweeby fucking 6 foot dude. I don't know. Bushy brow dude. I don't know. Take the people out. Look at the friggin' case. It's really, really sad. Just like in the Karen Reed case, Karen Reed wanted all of these. Hey, we want these phone records of all these people, right? What does the judge do? Nope. You're not getting any of that, right? Are you kidding me? Because Karen Reed's trying to show that she was fucking framed, right? What is Bryan Kohberger's team trying to show? That we have a 911 call, just like Karen Reed's case. John stays out there for how long on that lawn? Just like these kids getting brutally stabbed and murdered. Both of those two cases do not have a 911 call for hours upon hours upon hours. What was going on with the Karen Reed case? Well, that's when everybody says that the frame was that, they're moving stuff around. They're moving stuff with him. They're doing stuff with this, right? So in Karen Reed's case, we can say that all that shit's going on. And then the cops got involved, right? Right? And they did. And they 100% did. And they framed Karen Reed, right? Well, this case is trying to show us the same damn thing. Is that those kids were stabbed, according to the state, at 4 a.m. and 911 wasn't called until noon. What was going on? They were in the house. So somebody supposedly saw the killer and still didn't call 911 because they were frozen in shock. Suck my tits. Okay? If you want me to believe that, I can. Sure, no problem. But then she locks her bedroom door, as it's stated in the PCA. Well, somebody that's frozen in shock, she locks her door in her room and then just does what? Lays in waits to get stabbed too? You break. First, the IgG information is not material to the preparation of the defense of the defendant. The defendant is charged with killing 4 people, not with being related to a particular person. This is again gaslighting 101. I want you to use IgG. If I have no issues with IgG, you guys, I have an issue with, I just want the dates. Can I get the dates of your stupid ass investigation against me? Can I get the dates of how you think that you got to me? And that my DNA raw data is just being passed around like fucking, I don't know, prom night? Like, what is wrong with you people? Give me the dates. I want the dates. To like even write this is like, be snarky, and I hope somebody takes this paper and shoves it down your fucking throat. You can't be transparent and trustworthy when you're a cocksucker. Nobody trusts a cocksucker. Well, I see nothing but a lot of cocksuckers up here. Nobody's a fan of a cocksucker, even if you're good at it. I take that back. Probably a lot of guys are like, hell yeah, I love a good cocksucker. The mere fact that uploading the completed SMP profile into a public available genetic genealogy, they don't care about that. Again, this is just, you're just gaslighting. Again, that's not what we're talking about here. And this is why you lost on the motion. You lost this motion. The state lost. And thank God that they lost. And Judge granted this shit. The defendant does not, or I'm sorry, service led law enforcement to relatives of the defendant does not affect the strength of the evidence against him. That is the biggest oxymoron. You just said that you're not using it. So what do you mean the strength? Because, and then this is me, I said, I actually agree with you because there is no evidence against him. So there is no strength. There is no strength here because you don't have any strength behind it. Even with your stupid little lead, whatever you got, there's still no strength because it's lies. It's not factual data. The phone and the car aren't moving together. So I agree with you. Look at me. I agree because there is no evidence against him. So it does not affect the strength of the evidence against him. You're absolutely correct. You know, the strength of the evidence against defendant in terms of DNA evidence depends upon the confirmation, the confirmatory results from the STR DNA analysis between defendant's DNA profile and the DNA recovered from the K-bar knife sheath. Exactly. But how did you get it? How were you able to get his DNA to test it? Illegally. And that's where I say, exactly. And you got to compare that DNA how, motherfucker? How did you do it? By search warrants, correct? Now, were they legal, illegal, valid, invalid warrants? You don't think a dude or anybody for that matter that's a human being, like, just wait a second. You're telling me that man's going to be able to duck y'all and then not leave his DNA anywhere in public? As explained further below, the state intends to introduce the STR DNA analysis. Well, thank you for announcing that you do intend to, show that, right? Because that's the only thing you have. That's your only evidence against this man. Okay? And you're going to introduce it at trial. Well, so that's exactly why they have a huge problem with it. And it does not intend to enter any evidence pertaining to the development of an SNP profile or the tree building process for inculpatory purposes. They think that if you want us to, like, this is them trying to threaten, like, to say, like, well, I mean, I guess we can't talk about it because it's so inculpatory of him. When you talk such a big game, like you're bluffing. You got dick. The state has disclosed, look at this, now ready for this, just bomb drop here. Take this to the bank. The state has disclosed or will disclose the information it has related to the STR DNA analysis conducted in connection with this case. Ready? This was written in June of 2023, June 16th. It is 2025, January. Here's me. When? Still missing to date any DNA reports. Take that, Bill Thompson! You fuck! Woo! Now that's some titties right there. That deserves a little cowbell right there. Boom, boom. Now that is just absolutely crazy right there. The state has disclosed or will disclose the information it has related to the STR DNA analysis conducted in connection with this case. When? Because Ann Taylor says, Aunt Jay, we still, to this day, we got 5 DNA experts. We got no reports. None. And the best part is he tries to say, the state has disclosed. Get up out of here. Walk away. Ridiculous. Moto Man MX. But how do they get Bryan's DNA on the sheath if it was in fact planted? And how do you apply such a small amount? If it was planted, why wouldn't they plant a larger sample of DNA? Let me tell you something. If they were able to pull what they pulled, I don't think it was a small little sample. I just sat in Delphi and the Indiana lab, ISP, Indiana State Police over there. They don't even deal with touch DNA. They won't even bring it in. It's that unreliable. I put it out there. I said, if I was Ann Taylor, I would hit up that woman that testified in the Indiana Delphi case. I would go and find that woman. I would subpoena her ass. I'd sit her ass down in Idaho, and I would have her recite what she said in Delphi, that touch DNA is so unreliable, we don't even deal with it. It's crazy. And that's why when I was sitting in that trial, I was like, I can't wait to buy the transcripts for just her, because I want everybody to hear what this woman had to say, because I was blown away. I was blown away because of my involvement with this Idaho case and everything that's writing and dying on this sheath. Okay. And then for the woman to literally say how hard it is, you're not getting a sample like that. They couldn't get samples off of it. Do you understand Richard Allen's DNA was not at that scene? Stabbing. Okay, slicing throats. I absolutely love how there is no way you can misunderstand Lana's opinions. Couldn't be any clearer. Always get some giggles during this serious subject, right? Because I try. And like everybody was asking back then, and I know Annie Potts was a big asker, like, when are we gonna get come on, when is there gonna be a Franks hearing? When is there gonna be a suppression hearing? I mean, oh my God, all this stuff. All of this stuff is what has led up to that. Okay. It's a death penalty case. Ann Taylor and her team are going through every step methodically. Okay. Not because they're doing their job. That's not the only reason they're doing it. Okay. You know what it's like to have a lawyer fuck up your case? Just go ask Jennifer Drake. All those lawyers and cops fucked up her own husband's case. Damn. My superpower is zapping assholes in chat. I love it. Oh, I love it. No, I love all the other opinions. Let the opinions go. Just be kind in chat, love. The fact defendant was first identified as a possible suspect based on a database search simply does not matter. Simply does not matter. You're absolutely right. But what matters is everybody else that I don't care that if I was first, but he wasn't first, okay? There was other alternative suspects. All right. But I just had to show that to you. Now, I got more bombs for you. Again, this is why they want the IGG sealed, so that they would have never got any of this. Okay, remember, this is how hard 33 pages, how hard the state went to seal everything to do with IGG, and all Ann Taylor and her team wanted was basically like, we just want a timeline. We want a timeline, and you're gonna see in the response that only took 8 pages. Are you guys enjoying going through this, at least so you guys can see why I so passionately am all just about this, like, hey, yo, like, you're not going to violate my rights, okay? They're violating your rights, guys, too. These are our rights as Americans. And I'm sorry, I'm just not going to stand by and let the government continue to put up our asses. And I hope Trump dismantles the whole fucking FBI. Yeah, Atlanta. Woo! Okay. Moreover, IGG information could not support an argument from the defendant that law enforcement violated his Fourth Amendment rights by entering the DNA collected from the K-bar knife sheath into a... They're not. I don't even care about that. Okay? Like, they're talking about what they could possibly argue here, and it's like, a defendant cannot prove a violation of the Fourth Amendment without first showing he or she had a reasonable expectation of privacy in the place searched. Well, we'll deal with that later. Okay? What I want to talk about right here, this is me when I say, we just want the fucking dates, man. This is only self-serving for you. Okay? And Judge took it that way. Like, we want the dates to do what? What did Elisa say? To do a timeline, right? Timeline queen over here. Is that right? So it is so it is trial prep, okay? They're trying to say this has nothing to do with prepping for a trial. And it's like, yeah, no, actually it has everything to do with it. This is just gaslighting. The K-bar knife sheath was abandoned at the scene. Oh, was it? By who? Because I think that's we are not in dispute here. But the who is who we're in dispute of. But by who? We are in dispute of that. Okay. Just give us some dates. Second, the state did not rely on the IGG information to establish probable cause. I'm dead. Ann Taylor, if you don't win this, man. Second, the state did not rely on the IGG information to establish probable cause for the defendant's arrest. Did not present the IGG information to the grand jury and has no plans, Your Honor, to present the IGG information for which a protective order is sought as evidence at trial. Ready? What does Lana have to say about this? This is false. And why, what do I say there? This is false, and why the affidavit was wrote and how it was wrote was about November 29, 2022, finding Bryan's Elantra to misguide and mislead the tribunal. So basically, I'm saying that, no, this is actually false, and it's provable when you go and point out page, whatever, 5, 6, 7, whatever the hell it is, and show, look at how and where Payne puts November 29th, November 25th, you put be on the lookout. Then November 29th, you're making it seem like that's how you got to Bryan Kohberger. And how I know that that's fact is because this was all first. Then the judge's written order came in October after they had that big hearing, in August. And the judge's order made it very clear how he interpreted that they got to Bryan Kohberger. Well, because you guys said we didn't use it. So the only other thing I could think of is how you got to him was because of the November 29th friggin', that's how you made it seem in the affidavit. And now I get it. Like that just happened to, you guys were doing that at the same time. And it just happened to come back. Like, yep, it's Bryan Kohberger. And here you're already looking into the White Elantras and you already had his name. Okay. And then so it comes out that's not the case, right? So right here, this is absolutely false, but I love how Judge literally writes it in and says, I asked them directly. I asked them so many times, and they told me that the state did not rely on the IgG information to establish probable cause, and that is false. And Heather says, and I love this, I'm going to highlight this. December 20th is not November 29th, Brett Payne. Do you understand that? Love it. All right. Then it's just a couple more here. I said, the rule does not require the state to disclose what law enforcement does with the results or reports. I love this part. What? Like, no joke. Like, this is what they said. They said that they are citing because they said that Rule 16b-5 does not require the disclosure of the IgG information because the IgG information is not the result of scientific test or experiment. And guess what? They lost on this argument. They said, well, actually, it absolutely is because you're using DNA is biological. That's scientific. Get the fuck out of here. But good try. If anything, the state would have one of the detectives testify at trial only that they received a tip pointing law enforcement to defendant. And I highlighted this or just started because I would ask Ann, I would call Ashley Jennings to the stand. I don't give a shit. And I would ask her, what detective would testify to who got that tip? Who would be testifying? I would just want that information. The state reserves the right to present the IgG information at trial if the court requires the state to disclose the IgG information to the defense. And this was another way of saying, like, ooh, guys, if you really want this, we're going to use it. Yeah, use it. Use it. You're not going to be able to use it. So that's when they wrote this, is that the rule does not require the state to disclose what law enforcement does with the results or reports. We just want you to give them to us. Like, what do you mean? What you do with them? Moreover, a process, procedure, or investigative technique is not a scientific test or experiment merely because it involves the comparison of information. That's not what you did. You physically were working with DNA, like raw data, right? That you put into SNP profile. And like I said, they lost their argument here. Anyways, again, I cite this, that the judge disagreed. The product of the FBI's efforts, the product of the work product, right? The product of the FBI's efforts was a family tree comprised of hundreds of defendants' relatives. Put simply, the family tree is created by the FBI cannot accurately be described as the results or reports or scientific tests or experiments, and thus falls outside this rule. Guess what? This is the only thing I had to say about that. Judge disagreed. Take that. Similarly, the FBI tree created, or the family tree created by the FBI cannot accurately be characterized as reports or memorandums made by a police officer or investigator. And they go on to talk about that. And the FBI has indicated that they did not create reports or memorandums as they conducted the genealogy. Even if the notes jotted down by the FBI agents or the family tree constituted reports or memorandum, as explained above, those records are not in the possession of the prosecuting attorney. And then this is when I said, well, again, judge disagreed. And judge said, hey, actually the FBI's extension of the prosecution and the local police who asked for the FBI to aid them, and then they are part of it, and then they are an arm of it, and then, yeah, judge's ruling on October 25th, 2023, disagreed. Suck it. Just now, we get to, on June 16th, I told you guys I would point out the fact that, remember I said, I don't think that they were looking at emails so that they could do this. The state, so January 23rd, 2023, the state response to request for discovery. February 21st, 2023, the state's response to defendant's first supplemental. So they're saying, hey, we responded to you February 21st, 2023 to that request, okay? Then you guys asked for March 29th, state response to defendant's second supplementary request for discovery. They did that on May 12th, 2023. Remember what they were doing in April? Remember what they weren't opening up and they weren't providing? What was going on in April? April 19th, 2023. Remember Bill contacted Mowry and Jennings. And guess why they turned stuff over then on May 12th? Because Bryan was already what? Indicted. The grand jury was over. So they didn't. So if you see like February 21st, May 12th. See that? Remember I told you I would prove to you guys why they were holding shit back and not opening shit, and Mowry's off for 2 months taking fucking classes so that he can do whatever. Because when I said to myself, why is Bill stipulating to the fact to have a grand jury 6 months? Okay. They stipulated to have, I'm sorry, not a grand jury, but a preliminary hearing. Okay. They arrested him in January. Why would you ever do it in June? And they said, well, it's just a lot of volume of stuff that we have to get to you. Really? But here, Ann Taylor stipulates with Bill Thompson to have this June preliminary hearing. And then I think Ann Taylor knew exactly what they were going to do. Because when you know your opponent, if you want to treat this like a game, she knows how these motherfuckers operate. But I just wanted you guys to see that big gap. So technically on February 21st, 2023, they turned over discovery, and then not until May 12th. And then why don't you guys go take a look and see how much shit that they were asking for between those dates and beginning on January 23rd. And then this is what else is just great too. If you want me to, really want me to highlight it. Then they did something on May 12th, state's response to defendant's motion to compel discovery, and June 8th, 2023, the state's supplemental response to defendant's first, second, and third supplemental requests for discovery as fully set here. And so they're saying on June 16th, it was fully set for everything that Ann was asking up until that date of June 8th. And that's lies. Ann still doesn't have that shit right now. Ann is still missing her shit right now. This was 2023. You're never going to get dates and timestamps past me. It's 2025, and Ann still has no DNA reports. Suck it. Next up. On June 22nd, Jay Weston had something to say about that June 16th objection. Or I'm sorry, they put in a motion for the protective order. Well, here is the objection by Bryan's team. Objection to state's motion for protective order. Comes now Bryan C. Kohlberger by and through his attorneys. And here you go. And it says, so again, he wrote factual too. I would just be putting background if I was a lawyer. But Law enforcement later found a K-bar knife sheath, and this is the first time that we, as a community that's followed this case, this is the first time that we saw this word placed. And that's what this live is all about, the sheath. Okay? So law enforcement later found a K-bar knife sheath placed next to Miss Mogan on her bed. And so I want to remind everybody, when they want to talk about this case, the defense since 2023 has used the term placed. The sheath was placed button side down. That's where this DNA exists, allegedly. And partially under Miss Mogan and the comforter. And you're going to sit there and tell me that you only found a single source of DNA and it was laying on her body? On November 20th, the Idaho State Police Lab in Boise located DNA on the button of the sheath and performed STR analysis that led nowhere when ran through codis, other than to show the provider was a male. By December 17, 2022, the lab, they were aware of 2 additional males and their DNA within the house where the deceased were located, and another unknown male DNA on a glove found outside the residence on November 20th. And no, this is not Chris. This is not Chris. Chris did not find this. He wasn't there until after this date, but he wanted to walk around and let people act like that's the glove he found. Fuck you, Chris. You know you lying, fat fuck. Continue on. To this date, the defense is unaware of what sort of testing, if any, was conducted on these samples. So the reason this is important is because on December 17th, 2022, they did not have the name Bryan yet. Bryan Kohberger was not known. So how is the lab not running and testing these other unknown male samples? Like what the hell are you doing? But by December 17th, and the reason that he's using this date is because he can say that because something that they have has that date on it. But it could be before this. But I'm just saying, like, at this point. Remember, Bill Thompson then tells us in a hearing that nothing was done. We have nothing. Nothing was done with those unknown male samples. Remember? Bill Thompson says that. Further, these 3 separate and distinct male DNA profiles were not identified through codis, leading to the conclusion that they are not Bryan's. While this was ongoing, police were investigating many various possible suspects. Many of them provided DNA. At least one had his DNA surreptitiously taken from a discarded cigarette. Many also had their phones taken and downloaded. And remember, we have 67 downloads from devices. But no one's done anything with them. One area of the investigation had to do with a white sedan seen on a camera located at 1122 King Road. And hey, they took their first glimpse at that camera was November 18th. You guys, that's 5 days later. By November 25th, 2022, police believed the car to be a white Elantra and asked law enforcement to be on the lookout for one. Precisely how the police came to believe the car was an Elantra. This is why she was asking about this first initial report And then when the date changed, and Payne's over here like, I don't know. I have no idea. I have no idea. I have no idea what's going on. My name's Brett Payne. I don't know a damn thing. And yes, ma'am. That's correct, ma'am. Yes, ma'am. Yes, ma'am. I love it, though. Precisely how the police believe that this car was even Elantra is still unknown. A report from analysis for the FBI was dated March 21st, 2023, and that shows that this person heavily relied on a video of a car heading in the wrong direction. So this wouldn't be Linda Lane or any video, it wouldn't be 1112 or 1118. Okay, this was Ridge Road, and I know what address it is, and I said, oh, why was this report dated for this, and why was this all needed then? Well, it was for the grand jury, of course, right? And now this was the one that they're saying is 2011 to 2013. The state's latest filing admits that somewhere within all of this, they engage in investigative genealogy, and says admits, because this is the first that they've ever admitted it, which was June 16th, 2023. So they went from the arrest in January. Well, it was like this. We'll just put 1 all the way to June 2023 and didn't tell a soul that they used IGG until this day when they were like, we're going to get a protective order because we don't want to release any of these dates. It's all about the dates. The state's latest filing admits that somewhere within all of this, investigative stuff that they were doing, that they engaged in investigative genealogy using the DNA taken from the button on the sheath, and now claims that it was due to the use of this technique that it tipped. Again, now claims. So look at this. This is really, really important. When he says, and now claims, because they're going to argue in court that in that PCA, they most certainly claim that they got to Bryan via the November 25th BOLO and then November 29th. So this is going to be huge at the suppression. You could see, and now claims because before it was 100% November 29th that they led the tribunal to believe that this is when they got him and they knew of his name. And that's not true. And this is why I believe that the suppression hearing will be successful, as it should be, because it's lies. Well, they put up, when they did their little, breaking news for us, December 12th, 13th, they put out a picture, a stock image of not just one Elantra, but 2 Elantras, one having a sunroof and one not having a sunroof. Like, are you fucking serious? So you're telling me that your video can't even depict if it has a sunroof or not. You understand that? You understand that? Go look at the Shanna Gardner case. Okay, they were looking for a blue vehicle, a blue truck. I wanted to compare it to this case to see how they put their BOLO out. Well, guess what video they used or picture they used? They used the actual fucking truck as their picture. So just saying. So, it remains unclear what the police first relied on in focusing their investigation on Mr. Kohberger. Again, this was written in June, remember. No matter what came first, the car or the genetic genealogy, the investigation has provided precious little. My favorite this is literally my favorite line in any filing to date in any case. Precious little. I used it. You guys know because I love to go pro se in matters. I used it. I used that line in a filing. Your so-called investigation has provided precious little. There is no connection between Mr. Koberger and the victims. Now we just found out in this latest filing that they haven't even opened, what was it, 3.3 gigs of data from his phone. Didn't even open it. Mr. Koberger and the victims, no connection. There is no explanation for the total lack of DNA evidence from the victims in Mr. Koberger's apartment, office, home, or vehicle. Hey, mainstream media, stop bullshitting, and can you please put this out? Because Scott Roeder was under the impression that there was all this evidence in these areas. Okay. And the state has yet to correct this. In fact, the state now hasn't turned over any DNA reports. And they said they were going to, or had in June of 2023. It's January 2025. So if you can go ahead and mainstream media, just clip this portion, I'd really appreciate it. Just to help out people that can't watch my lives for 2 hours. In essence, through the lack of disclosure and their motion to protect the genetic genealogy investigation, the state is hiding its entire case. Exclamation point. Facts. The state apparently thinks that they need not explain how they came to think that it was Mr. Koberger's DNA on the sheath. You understand that? You understand if they would have been able to obtain a protective order, they would have never had to explain this sentence right here. Apparently, presumably the defense is expected to accept at face value that the sheath had, keyword had, touched DNA just waiting for testing by the FBI's MIDRID resources. Another fucking amazing sentence. Additionally, the defense is to guess whether the state focused its investigation on Mr. Koberger via a bizarrely complex DNA tree experiment or through its faulty identification of the vehicle involved in this case. There you have it. So we are totally in dispute of make, model, just the damn vehicle. Perhaps unsurprisingly, Mr. Koberger does not accept. He does not accept the fact that his defense does not need this information. It rather obviously falls within the ambit of Rule 16b4 and 5, a fact the state's briefing makes clear in its kitchen sink approach to their briefing. The state begins their argument claiming Rule 16 has no interest in IgG testing, and then ends their argument claiming that somehow people will stop sharing their genetics if they were to realize the government is watching. Both arguments must fail. Get it. To begin with, the state apparently only wants to prevent Mr. Koberger from seeing how the IgG profile was created and how many other people the FBI ignored. During their investigation. In essence, the state argues that if the latter, or if the later STR testing is accurate, then there is no reason to concern ourselves with how the state came to investigate Mr. Koberger. What has Lana Oriani been saying this whole fucking time? I swear, if Jay does not come on my show and do an interview when this is all over, I'm going to be super pissed. Because I just want to call it Martini Monday with Mr. Jay Weston. No last name needed. State's brief at 9. What the state's argument asked this court and Mr. Koberger to assume is that the DNA on the sheath was placed there by Mr. Koberger. Shut up, Jay. You guys, I am just reminding us of how ludicrous this is. And that nobody wants to talk about the fact that the defense has been saying since day one that, wait a second, you guys just want us to accept the fact that Mr. Koberger put that there, right? Right? Well, now they actually have a huge ass amazing argument on their hands to say that, listen, not only do we argue that he didn't put that there, but now we're going to show you how they then planted, in a sense, data to make it seem like the phone and the car were in sequence when truly it wasn't. So now let's get back to this whole planting of the sheath. Does that now make it more probable than not that this is fucked up as well? And that's my argument. That's my argument, is that, holy shit, you know, I use the Karen Reed case because it's happening right now. It's corruption. Karen Reed, in my opinion, is factually innocent. Okay. And the police were involved in fucking that girl, right? Well, how come the police can't be involved in fucking this man? They're laying it all out. Just like how Alan Jackson and Yannetti are laying it all out for us with Karen Reed. If you want to keep your eyes closed, that's on you. But I don't know, you know, I truly mean it when I say that, you know, Karen Reed went to that house, so she was physically there. She dropped off John in that vehicle, okay? And all these, you know, questionable things that, you know, then she backs up and hit his car. Did it crack it? Well, here in this case, like, just even none of that exists. And they just want us to believe, hey, Payne put together this probable cause affidavit that's based off of nothing but lies. I mean that. Based off of data that's incorrect on purpose. So that he can get what? Warrants to get what? Hey, let's just show that he's hitting off of cell towers in that area. And then we can just say that, hey, we have reason to believe that he was stalking them. So we need to go and get his devices, and we need to go through his stuff so that we can show that he was stalking. We got to connect him to these victims. You know what I mean? And then even though that none of this shit was returning a damn thing, they still plowed through and kept laying it, like laying pipe, just all. And then at every turn where they were supposed to be something fruitful, there's nothing. How is that possible? How is that possible? At every turn, when they went to go get something, there was nothing there that they said that they were going to go and like that should be there. And then I hear people say, he had all this time to clean up. And then Scott Roeder said, you guys can hate Scott Roeder, love Scott Roeder. But you know what he said immediately to me? He said, Lana, do you know how that there's going to be more evidence of a cleanup than there probably would be there's going to be all those chemicals that you used. There's going to be the evidence of that cleanup in that car. Okay. And then people say, well, then he must have just Dextered it all out and wrapped it all with saran wrap or whatever the hell they're, tarps and shit. Okay, if you need to say all of these things, that's fine. But now who's the conspiracy theorist? Who's the conspiracy theorist now? Why were you clearing people? Think about it. You cleared people because, oh, they weren't on the cell towers. Okay, so they're cleared. Like someone like Hoodie Guy. Hoodie Guy was on the cell towers. He's cleared. Well, Bryan Kohberger was on the cell towers. Continuing on with my favorite here. So the state's defendant. What the state's argument asked this court and Mr. Kohberger to assume is that DNA on that sheath was placed there by Mr. Kohberger and not someone else during an investigation that spans hundreds of members of law enforcement and apparently at least one lab the state refuses to name. Boom. Do you see who he is pointing the finger to? I'll just highlight it for you guys. During an investigation that spans 100 members of law enforcement and apparently at least one lab that the state refuses to name. Perhaps most puzzling is the state's argument that while Rule 16b-5 requires them to turn over the results or reports from scientific investigations, it does not require the state to disclose what law enforcement does with the results or reports. Remember how I just made like a crazy, I was like, wait, excuse me? Like, what? Let's see how Jay feels about this. State's brief at 14. First of all, that sounds like an admission that the information as to how the IGG was carried out should be disclosed. Like, we don't have to tell you. Like, okay, first of all, that sounds sus as fuck. Damn you, Jay. You took the words right out of my mouth. It must have been while you were kissing me. A little bit of meatloaf for you guys. Cheers. They try to keep out chain of custody in this case. You guys, God, I love Jay. Jay just brings it. Frankly, the fact that members of... Okay, so where was I? Second, what law enforcement does with results or reports is covered by Rule 16b-6, statements of prosecution, witnesses, and aides, police reports. Frankly, the fact that members of the FBI are so concerned about permitting Mr. Kohberger to know what they were up to with what was supposedly his DNA does not give one the impression that there is nothing to see here, as the state seems to imply. You guys, this is just so classically amazing. You know? Exactly. Like, how damn dare it's just like, dude, wait, I can't defend my case. I can't know about my case. You want me to be what? Just accept the fact that, hey, nope, this is how we got to you and you can't question it. And we're not going to give you any chain of custody when we got it, when we did what, nothing matters, because guess what? That DNA on that sheath belongs to you. You got to be out of your fucking mind, right? You guys, when we were younger, our parents told us to go clean our rooms. Why? Because I said so. Okay, yep. That's our parents. Well, guess what? That's us being 5. Well, the government, they're not our parent. They don't say something and we say, okay. The greatest thing about being in the United States of America is because we have freedom of speech, number 1. Number 2 is that, no, you have to prove your motherfucking shit. I am innocent and so proven guilty. And now, you ain't trying to prove anything. You just want us to accept things that you say. Kiss my white ass ball. You know what that's from? Happy Gilmore, kiss my white ass ball. Make sure you guys thumb up the video, share it, whatever. We're going to be at that 2-hour mark. That's where I want to keep it. So finally, the state's claim that IRC 16G2 applies to the matter is quite bizarre. Presumably, the independent company the government relied on was paid for its work and would stand by it in court, right? The state provides no real argument as to why the company needs to be protected. Mr. Kober is left to suspect that they wish to keep their methods from being questioned. To the extent that there is some concern about intellectual property that can be addressed via a protective order that pertains or permits Mr. Kober and his defense team to review their work. Okay? Second, the state appears to argue that every living on Earth that provides genetic information is A, unaware that their DNA could be used by a government somewhere for something, and B, is an informant within the meaning of the term in the rule. The state citations to cases involving actual informants hardly help it make this incredible leap. No court has ever found the existence of a DNA informant. I'm dead, Jay. Fucking A, man. Can I just get some J shirts? You know? There we go. God, that's so priceless. It would appear that the state is acknowledging that the companies are providing personal information to the state and that those companies and the government would suffer if the public were to realize it. The only two databases that allow access are ones that already inform their users, and those users can opt in to allow law enforcement searches. The statement by the government implies that the databases searched may be ones that the law enforcement is specifically banned. They're banned from, which explains why they did not want to disclose their methods. If the fact that the government is looking at the genetic information that people are sharing was at all an issue, then the state's very public acknowledgement of such investigations was clearly a big mistake. You know, and that's where my mind goes with the whole, like, did they really use IgG when he talks about that? And that's for my brain. That's probably too advanced for this segment, but that's where my brain kind of goes. In any case, it is hard to understand why Mr. Kober should be the one to suffer, because these companies and our government choose to either mislead, right? That's that big keyword that we're going to be talking about January 23rd, or not educate the public, according to the Pew Research Center. In February 2020, 48% of respondents thought it was acceptable to give their DNA to law enforcement to solve crimes. 33% said no, and 18% were unsure. So he's just talking about that, blah, blah, blah. I don't care about that part. There is no federal law about the sharing of genetic information, but multiple states have begun regulating police use. Mr. Kober has reasons to be extremely suspicious of the IgG used in this case. Rather than seeing it as some sort of complex tree building that led to him, it appears far more like a lineup where the government was already aware of who they wanted to target. Do y'all listen to this shit? I mean, please. You understand? That is a very kind way of saying somebody is framed. Do you understand that? And where would he get that idea from? I'm going to tell you who. Bryan. Bryan Kober would be saying that he was framed, okay? Instead of just giving us the shit, why are you doing this? It just, like, And when I want to say like to somebody that's just like, why are you defending him? I'm defending us. I'm defending we the damn people. And that's what public defenders are supposed to do. And they're doing a damn good job here. And everybody wants to go at their throats. Ann Taylor has lined up 25 experts. How many experts did fucking Richard Allen have? Okay? By the way, Richard Allen's defense team is going to be on Defensive Diaries tonight, kicking off with Jennifer. And the two boys are Wednesday, Thursday. Listen, I love that defense team to death. No, pun intended, but they didn't have like the type of defense that Bryan Kohberger is mounting here is what Richard Allen should have had. Okay. You don't hear Ann Taylor talking about how there's no money being given to his experts, right? Or to her team getting paid, right? Well, that wasn't the case in Richard Allen's defense situation and with that case. And I think a lot of it has to do with the fact that Bryan Kohberger's case is a capital case because it's a death penalty case. I wish that Richard Allen's was a death penalty case because then everything could have been different. So it's almost like I'd want that. Truth and transparency, are you still following Karen's case? Of course I'm following Karen's case. I refuse to listen to Hank's bullshit, though, today. The funniest thing I fucking heard and listened to was him trying to argue the fact that, listen, when you guys get a dog bite or a dog attacks you, let me know the next time you don't go to the ER and just handle your situation right then and there. And when you actually make an appointment to have surgery, okay, because you just suffered a dog attack. I mean, the shit I heard today, get fucked, Hank. But then people could just say he's doing his job. No, he sounded like a little fucking crybaby. Take your $250 an hour and shove it up your ass. I'm sorry, but there's no lawyer on the planet, even in Ohio, that would take you on for $250 an hour. That's how desperate you're trying to do what, Hank? Go blow dry your hair. So rather than having the investigation done by someone blind to the fact, the FBI chose to do it themselves. This is akin to the police pulling in Mr. Kohberger and 5 of his cousins off the street and then pointing at him. So again, rather than having the investigation done by someone blind to the fact or to that fact, the FBI chose to do it themselves. Right? The only authority the state has in its favor that is on point is a trial court order from a California case that settled before it could lead anywhere. That decision relied on is People versus Johnson. The court in Johnson was not deciding whether a defendant had a right to know how he was identified, only that his identification could come in a trial without a mini trial about it. Love him. A better case on the issue is State versus Artiga. So in this case, an appellate court heard similar arguments about the need for software used for facial recognition to be discovered to the defendant, though they would not be admitted at trial. The court considered the matter found as follows. So, and then, yeah. And then if you want, I'm just going to leave this here. Write down this date, July 14th. It is the reply in support of motion for protective order because then the state replied. Okay. And my recommendation is that you go to the Idaho page and then you could see the back and forth here. But Judge ruled on this. Okay. And that's the order I talked about yesterday. But this was all the background information. And I'm telling you right now that everybody and their mother that read that affidavit thought that they had Bryan Kohberger on November 29th. Anybody that says anything different is a complete fucking liar, and that would include Megan Marshall. So I would be subpoenaing these people. I think January 23rd is going to be lit as a tit. We're going to be back here. I'm trying to prep it, bring it all to you guys so that you know what's going on for this huge day in Idaho on January 23rd, 2025. Until that time, be kind, take care, and peace out. For the fact that Bryan was not welcomed to come in that home, meaning nobody opened the door for him, meaning he came in unlawfully into that home. He was not invited in any type of way. And for the longest time, that's been overlooked and not talked about. But now it